Thank you so much, Tammy, and thank you all for having me. I am really excited to talk with you all today about narcolepsy and Social Security disability. And I hope to help everyone to get a better understanding of what Social Security disability is, how to qualify, and just how the process works. So, with that being said, I need to first start off with a disclaimer because I am an attorney. I am an attorney in private practice. And so the opinions that you hear today are going to solely be my own. This is an informational session, it's for educational purposes, and I do not represent the Social Security Administration. As I said, I'm in private practice, so my job is to help my clients to obtain benefits. So I'd like to start off first with the really big question, which is what is disability? What does it mean to be disabled? And if we could advance the slides, please. So, let's go back one more. So for many people, when they hear the word disability or they hear disabled, um, a lot of people think something along the lines of, well, it means that, this person isn't able to get out of bed. This person isn't able to function at all. And that is not what it means to be disabled for Social Security disability purposes. So the Social Security Administration says that being disabled means that you are unable to engage in what they call substantial gainful activity because you have a physical or mental or both impairment, so a combination of physical and mental, that can be either expected to last in death or which has lasted or could be expected to last for at least 12 months. So, to put it in much more understandable terms, being disabled means that you have a condition or conditions that keep you from being able to work full time, and that those conditions are expected to last for at least a year. They don't have to last a year before you apply, but they have to be expected to last at least a year. Now, there are two disability programs, and many of you have probably heard of at least one. Next slide, please. And those programs are Supplemental Security Income, which is commonly known as SSI, and the other program is the Social Security Disability Insurance Benefits Program. So that one is typically known as SSDI. And so these are two programs under the same umbrella of disability. So when we talk about disability, we are talking about one or both programs. You can be eligible for both programs. Many people are eligible for one or the other. But regardless as to which program you are eligible for, the rules are the same in terms of what you have to prove from a medical standpoint to show that you're disabled. Disability is a federal program. However, there are the states also supplement the disability program. So there are going to be a few nuances as it relates to supplemental security income in particular because of some additional state supplements that are available. So SSI, I want to start with SSI because this is the program that is typically thought of or known as like a safety net. And the benefits for SSI are a monthly check, and you also get Medicaid health insurance. Now, SSI typically is available for people who may not have worked at all, or they haven't worked enough to qualify for the other program, which is SSDI. So SSI is an income and asset sensitive program for people who are disabled. And what that means is that you have to have very limited means in order to qualify for SSI. They will look at bank accounts, 401ks, vehicles, property, all of those things have a monetary value. And with SSI, you are not allowed to have, if you're single, more than $2,000 in income and assets. And if you're married, you're not allowed to have more than $3,000 in income and assets. Now, SSI does not include, when they're trying to figure out how much you have in income and assets, they do not include one vehicle, and they do not include the home that you live in. But essentially, everything else is an asset. And so you want to make sure that if you don't have the work experience and you haven't paid in to SSDI, that you also have limited means in order to qualify for SSI. Now, SSI pays $943 per month maximum. There are a few states that have an additional supplement on top of that, but in terms of just SSI and their payment, it is a maximum amount of $943 a month. Because it is income and asset sensitive, there are many people that receive SSI that don't get $943 a month. They may get less. And that could be because they're getting some other sort of financial support, or they're working a little bit, or they're living with someone else. So the SSI payment can fluctuate from month to month, depending on any other resources that you have coming in. But one of the best things about SSI, as I stated, is that it does come with Medicaid health insurance. Now, typically what we see in terms of SSI eligibility, children can be eligible to receive benefits for SSI, so children under 18 that are disabled. And then for adults that receive SSI, it's oftentimes, like I said, adults who've never worked before, or they may have worked, but they didn't pay in to retirement and the disability program. SSDI, on the other hand, is an insurance program. And so what happens with SSDI is that as you work, if you're an employee, as you work and you pay your FICA taxes, you are also paying into retirement, and you're paying into disability and survivor's benefits. But from the disability pot, that is where you can become eligible for SSDI if you've worked enough, long enough, and paid into the system. Typically, you have to have worked 5 out of the last 10 years and paid in to be eligible for SSDI. In addition to that, for individuals who are self-employed, you too can be eligible for SSDI, but you have to pay your self-employment taxes. So you have to pay the SECA taxes to make sure that you have paid in, that you've earned quarters of coverage to be eligible for SSDI and, of course, retirement. So one of the main differences between SSDI and SSI is that SSDI is not an asset-sensitive program. That means that it doesn't matter how much money you have in the bank, what kind of property you own, who you're living with. None of those things can disqualify you from SSDI eligibility. So they're not concerned about what you have as far as assets are concerned. The payment is also going to differ from person to person. So for SSDI, the amount of money that you will receive each month depends on how much you paid into the system. And so the maximum amount for 2024 is $3,822 a month. I think the average SSDI payment is somewhere around the $1,500 a month payment. But again, there's quite a bit of variation from person to person as to how much you're entitled to receive under SSDI. Now, SSDI also comes with health insurance. Instead of Medicaid, it comes with Medicare, which is the same health insurance that you would receive otherwise at age 65 if you weren't disabled. The only difference with SSDI is that you have a waiting period for that Medicare health insurance, unfortunately. And it is a 29-month waiting period. So if Social Security finds that you're disabled and you start drawing benefits under SSDI, you'll start getting the paycheck every month, but you will not get that Medicare health insurance for 29 months. And so you'll have to look to other sources, such as the marketplace, to try to find health insurance in the meantime. Next slide, please. So one of the biggest misconceptions that I hear from clients and from prospective clients about this entire disability process is that people, are under this assumption that Social Security just rubber stamps applications, that you file your application and they just stamp it and they say we're denying the claim. And that is not how it works. There's actually a very involved process in order to make a determination about each and every disability claim. So the first thing that happens if you apply is that, of course, you've got to fill out this application. And I will tell you, the application for benefits is confusing. The first thing that you have to do is figure out, am I applying for SSDI? Am I applying for SSI? Am I applying for both? So that's the first big hurdle that you have to kind of get over, is you need to make sure that you are applying for the correct program. You need to have a lot of information available before you apply. You need to have information about your, of course, conditions, the conditions that you feel keep you from working, the medical providers that you see, including doctors, therapists, hospitals. If you are a student or you were recently a student, you'll need information about school and teachers sometimes. If you've attended any vocational type programs, you'll need information about those programs. So you need to gather a lot of information before you apply. And then Social Security also sends a lot of reports. They will send reports asking you about your work history. So you'll need to go in detail and be able to explain what you've done over the past 5 years in terms of each job and the requirements for each job over the past 5 years. They also send reports about what they call function reports. So reports to try to figure out what you do during the day, how your condition or conditions impact your daily functioning. So they take all this information, and the first thing that Social Security will do after you apply is they need to figure out if you are actually eligible from a technical standpoint for the program that you've applied to. And what I mean by that is, if you've applied for SSI, part of their application is going to ask you about assets and how much money you have in the bank and how many cars you have. So at a local level, when you apply, the first thing, if you've applied for SSI, the first thing that they're going to do is make sure that if you're single, that you don't have more than $2,000 in income or assets, or if you're married, that you don't have more than $3,000 in income or assets. And if your income or assets exceed their maximum, then they are going to deny you. And they are going to deny you even though they haven't seen a single medical record. And that's because you don't meet the technical, or what they call non-medical, requirements for that program. So the same holds true for SSDI. If you apply for SSDI and you don't have enough work credits, let's say you've only worked one job and you worked there for a year, then you are not going to have enough work credits to qualify for SSDI. So they are going to deny you at that time because you don't qualify for that program. So one of the things that I often see is people will be denied and they'll receive what we call a technical denial because they applied for the wrong program. And they are under the impression that Social Security is just saying, no, we've looked at the medical and you're not disabled. Social Security hasn't looked at the medical. They've only made it to the initial eligibility review, which determined that you don't meet the qualifications for the program. So assuming that you have applied for the correct program, what happens at that point is that your file goes to Disability Determination Services, which is known as DDS. Now, even though I said earlier, Social Security is a federal program, but states are also involved in disability claims. Every state has a DDS. And so after you've applied and you've applied for the correct program, your file is going to go over to DDS. And that is where the file review, the medical review, actually takes place. Next slide, please. So as I stated, DDS is a state agency, and their job is to develop the medical evidence. And by that, I mean, you have already provided information in your application about the doctors that you've seen and everyone that you've treated with. So their job is to request medical records, and ultimately they are going to make a determination as to whether or not you meet the requirements for disability. And they use what's called a 5-step sequential analysis, which we'll talk about in a moment, to determine whether someone meets the requirements. So at DDS, each claimant or applicant has a team that works on their claim. And the team consists of an adjudicator. There will be a physician and or a psychologist who reviews the medical records. And there will also be a vocational consultant that talks about the work aspects. Now, the adjudicator is like the captain of the team. The adjudicator is the person that makes sure that the medical records are requested, that they have all the information from you about your work history and things like that. And the adjudicator makes sure that the state agency examiners, which are either the physicians or the psychologists that work for Social Security, have reviewed your file. And then once that file is reviewed, the state agency examiner, so that's either the physician or psychologist or both, is going to give an opinion or opinions about what they think you're able to do. And based upon those opinions that they give about what they think you're able to do, the vocational consultant can then say, all right, well, this person has these limitations and here's their work history. And they look at your work history and they decide whether or not you're able to do the jobs that you've done in the past or any other jobs given your limitations. Now, one thing that also happens at DDS is there will be a determination made as to whether you need a consultative examination. So a consultative examination is an independent examination that is performed by either a medical doctor or a psychologist. Social Security pays this individual to examine you. So the state agency doctors that I talked about earlier that work in-house for Social Security, that read your records, have never met you, and they will never meet you. They strictly do a records review. But sometimes Social Security feels like, yes, we've got records from, Angel's doctor, but we still need someone to do an exam. And that could be a physical exam, or it could be a mental health exam, or both. And so that consultative exam is what Social Security will pay for and they will send you out to do. And sometimes because of COVID, they'll do these exams by video, but traditionally they are done in person. And so it's a one-time exam where Social Security makes the appointment for you. They send you out for this exam. And as I stated, they pay that examiner, and then the examiner will write a report. and submit that report to Social Security. And they will look at that report when they are making their determination about what your limitations are and whether you're able to work. So all of those things happen after you filed your application and after Social Security is satisfied that you meet the technical requirements for the program or programs that you've applied to. For all of the people that apply for disability and get approved for disability, about 25 to 33% are going to be approved at this level at the initial stage. And it typically takes anywhere from 6 months to 14 plus months to receive a decision at the initial level. If you get denied, after you have filed your initial application and gone through the steps that I have just described, then you will have 60 days to file an appeal. And I strongly recommend that if you get denied for disability, that you file an appeal. That takes us to the next step, which is reconsideration. Next slide, please. And let's skip this slide. We'll come back to the 5-step sequential analysis. Thank you. So at reconsideration, the claim is back with DDS. And what DDS does at that point is they are doing an updated review of the medical and all the other evidence in your file. So they are going to ask you, when you file your appeal, they are going to ask you, tell us about the doctors or professionals that you have seen since you applied. So they are just trying to figure out what has happened since the time that you've applied so that they can obtain those records, and they'll go through the same process. Okay, there'll be an adjudicator, there will be a physician and or a psychologist that will review the medical records. They will decide, do you need a consultative examination if you didn't have one before? If you didn't have one before at initial, they may decide that you need one now. And sometimes you may have had one at initial and they'll send you for another one at reconsideration. It all just depends on whether Social Security feels like they need additional evidence. Now, at reconsideration, unfortunately, the likelihood of getting approved is pretty slim. Statistically, about 10% of people that get approved are going to get approved at reconsideration. So for most people, if you were denied at the initial stage, then Social Security at reconsideration, they're going to look at things and say, okay, well, we said that she's not disabled. She's not disabled. That happens 90-ish% of the time. And at reconsideration, it can take anywhere from 4 months to 14 plus months, again, to get a decision. So the timeline to get through the first 2 typical steps of the disability process can be extremely long. I mean, it can be anywhere from 10 months to over 2 years just to make it that far. So I want to go back a slide to talking about the 5-step sequential analysis. I had mentioned that before, and discussing what happens at DDS and when your file is being reviewed by the physicians and the team at Social Security. So the first thing that Social Security wants to know when they're trying to figure out if you're disabled is, are you working? And contrary to popular belief, you can work and also be entitled to and receive disability benefits. The question is, how much are you working? So Social Security allows you to work and receive disability benefits, but it's only if you are falling within their guidelines in terms of work activity. So when they're going through this analysis and they ask the first question, is the applicant working? If the answer is no, then you've moved from step 1 to step 2, okay? But if the answer is yes, then they need to figure out, how much are you working? How much are you making? Are you engaging in what is called substantial gainful activity? And Social Security actually puts a dollar amount on substantial gainful activity, and it changes every year. For 2024, the dollar amount is $1,550 per month, and that is gross. That's before taxes. So if you are working, Social Security is going to say, how much are you making? They want to know how much money you're making every month. And if you are making $1,550 per month or more, you are not eligible for Social Security disability benefits. So if that's the case, and let's say you're working and you're making $2,000 a month, then Social Security is going to send you a denial letter. You're not eligible. You cannot get benefits. You're making too much money. But as long as you are working, let's say you're working part-time and you're making $600 a month and you're working at the grocery store, then Social Security is going to say, okay, she's working, but she's not engaging in substantial gainful activity. So we can move on to the next step of the process, or the next step of the analysis, which is, does the applicant have a severe impairment that will last 1 year or more? And so as long as that impairment is severe and it interferes with your ability to perform work activities, and it's expected to last at least a year, then you can move on to the next step of the 5-step sequential analysis. If the condition is severe and it's not expected to last a year, if it's something more temporary, then you're going to get denied because it has to be expected to last a year. An example would be, maybe you broke your leg and you're not able to work. Barring any complications, the leg will be expected to heal within a number of months, and you'll be able to return to work. So Social Security would say you do not meet the requirements for disability. So assuming that you have that severe impairment that's going to last, or expected to last, a year or more, then they move on to the third step, which asks, is your condition listed in the Code of Federal Regulations or of equal severity? So there is a group of listings, is what we call them, in the Code of Federal Regulations. And basically what it is it breaks down the body into systems. For example, there is a set of listings for the cardiovascular system. And it gives very specific details about conditions that you may have and how they measure the severity of those conditions. And I will tell you all that there is no listing for narcolepsy. So, in going through the 5-step sequential analysis, no, narcolepsy is not listed, but it could be of equal severity, which we'll talk about a little later. So let's say that no, the condition is not, you don't meet a listing or equal severity, then they continue with that 5-step sequential analysis. If they find that you do meet a listing or of equal severity, then they will say you're disabled, and they stop right there. They don't need to go any further. For most people do not meet a listing, and they have to move to step 4, which is, does your condition prevent former employment? So does your condition prevent you from doing any jobs that you've done within the past 5 years? If you've never worked, then that's easy. You don't have any former employment, and they have to move on to step 5. But, depending on your age, if you're a younger individual, then they've got to move to step 5 anyway, which is, does the condition prevent any other employment? So does the condition prevent you from doing any other job, even if it's one that you have not done before? So the five-step sequential analysis can be a little tricky because there are a lot of details that Social Security has to sift through when they're trying to figure out whether you meet the requirements for disability. Next slide, please. So where we left off was reconsideration and the unfortunate low percentage of applicants that are going to be approved at reconsideration. Most are going to get another denial letter. So you have 60 days again to appeal that denial. And that brings us to the next slide, where you will request a hearing in front of an administrative law judge. Now, this is the stage in the disability process where most applicants are successful. So of all the people that get approved for disability, about 60-ish% had to go all the way through to this level, which is an administrative law judge hearing. And that's for a couple of reasons. One, the administrative law judge, you will see and you will talk to the administrative law judge. Now, you may not see them because of COVID, and now hearings can be done by telephone, by video, or in person. So if you have a telephone hearing, you will not see the administrative law judge, but you will be able to talk to them. And the administrative law judge gets to do a de novo review of the evidence. And what that means is that they are not bound by the previous denials. So even though you got denied at initial, you were denied at reconsideration, the judge gets to make a brand new and fresh decision. And part of the judge's decision making is going to include being able to talk to you. So you will get the opportunity to explain and answer questions from the judge about your symptoms and how they affect you on a day-to-day basis, and complications or side effects from medications, and really to be able to answer any questions that the judge has. If you are represented by an attorney, your attorney is going to help develop your case. Your attorney is going to be able to ask you questions. Your attorney is going to be able to prepare you for this administrative law judge hearing so that you know the things that you can expect and potential hurdles that you may encounter. There will also be at the hearing a vocational expert who will testify about your job history, about employer tolerances, things that employers will allow and won't allow, and things that may be viewed as accommodations. And with the hearing, they typically last anywhere from 30 minutes to an hour. They are closed proceedings. So the only people that are typically involved in a hearing would be you as the claimant. If you have an attorney, your attorney will be involved, the judge, there will be a court reporter, and also that vocational expert. So a very small hearing in order to make sure that your privacy is protected and that you are able to provide testimony, which is testimony under oath. So one of the other benefits of the hearing is that the administrative law judge gets to look at all of the evidence. So the evidence that was reviewed at the initial level, at reconsideration, and even the evidence that has come in between, the reconsideration when you updated Social Security and even the day of the hearing. So they get to look at much more of a big picture. They get to look at a longer time frame to kind of figure out what has happened with you. In instances where individuals have conditions such as narcolepsy, there can be long periods, there can be years where you are experiencing symptoms before you get to that diagnosis. And so it is helpful for the administrative law judge to be able to see really a big picture and to be able to say, okay, well, we can see, the narcolepsy symptoms were impacting you 4 years ago. They just didn't know what it was. And so, all of those things are really helpful when a judge is evaluating a claim. And at the hearing level, the wait time to get to a hearing can range anywhere from 6 months to a year or more. So it is reasonable to expect that a disability claim could last 2 to 3 years. You could be involved in this process for a very long time. Some people are fortunate enough to get approved earlier on in the process, and so it may not, maybe 6 months or 10 months. But I tell people to expect and plan for it to be a long process. Next slide, please. All of you who are impacted by the symptoms associated with narcolepsy know that this is a long road. And one of the good things, I'm going to say it's a good thing and also can be a bad thing, is that while Social Security does not recognize narcolepsy in the Code of Federal Regulations, the listings, they do have some guidance on how narcolepsy claims should be evaluated. So that's the good news, is that there is some guidance. The not so good news is that the guidance that's available for Social Security employees, for judges, for all the decision makers, the guidance that's available to review is old and it's outdated. So you can see here, the evaluation of narcolepsy in Social Security's operational program guide. They developed this back in September of 2016. So almost 8 years ago. And what the agency said about Social Security, about narcolepsy, is that, it's a chronic neurological disorder, okay, characterized by recurrent periods of an irresistible urge to sleep. Agreed. Here's where we run into the first problem. Accompanied by 3 accessory events. So that means, according to this guidance, that if a person has narcolepsy and they filed an application for disability, we are expecting to see 3 accessory events. We are expecting to see cataplexy, hypnagogic hallucinations, and sleep paralysis. Now, we all know that cataplexy is associated with narcolepsy type 1. Social Security does not distinguish, they do not say a word about there being 2 types of narcolepsy. So this entire evaluation is essentially based upon narcolepsy type 1, which the literature now shows is not the more common of the 2. So it goes into some detail about what an evaluator should be looking for, or a judge should be looking for, when they're evaluating a narcolepsy claim. So I find that to be problematic because it's outdated and it doesn't distinguish between the 2 types. And if you have narcolepsy type 2, then it looks like you don't have narcolepsy according to this guidance. Next slide, please. Also, per Social Security, there are signs and symptoms, and this is a little better, but again, this is still from 2016 that they have, provided to allow for some guidance, because most people are not familiar with narcolepsy, and so they acknowledge that there are no physical abnormalities, but of course, they're saying, with the exception of sleep studies, all the laboratory studies will be normal. Most of the signs and symptoms, as described in this paragraph, are okay, except when we get down to cataplexy. And they state that cataplexy is observed in 70% of all cases. And again, that is not what we know about narcolepsy today. So that is another hurdle that you have to face with a narcolepsy claim. Next slide, please. Social Security also provides some guidance as to how the examiner or the judge is supposed to determine how severe the narcolepsy is. And one of the first things that they say is, narcolepsy isn't close to any of the conditions that are in the listings, but when you are looking at the severity, the closest listing that you can equate narcolepsy with is epilepsy, so seizures. And so they are saying that while you cannot find that an individual with narcolepsy meets a listing because there isn't one for narcolepsy, you can find that the severity of the narcolepsy equals the listing for epilepsy or seizures. And what needs to be done is that they need to evaluate you over a period of 3 months of prescribed treatment. And for most people that have narcolepsy, that's very easy. There have been years of prescribed treatment. So the 3-month, measure is pretty easy. But they also go into some details about, you don't need to have an EEG, that, they most importantly need to obtain ongoing information from a treating source. So from your neurologist, your sleep specialist, whomever you see, is going to be critical in your claim. You want to make sure, because narcolepsy is not well known and because the guidance that's available is very outdated, you do want to be sure that you have the support of your treating physician who can explain, okay, my patient has narcolepsy type 2. There are 2 types of narcolepsy, and here are the symptoms associated with narcolepsy type 2. And my patient's symptoms are reasonable given that diagnosis. This is how I arrived at that diagnosis. So a physician's input is very important for your disability claim. Next slide, please. And that goes to proving the severity. So first, of course, you need to have medical evidence. There need to be treatment notes from whatever doctor you see about your symptoms. So if you are a little more stoic and you go to the doctor and the doctor says, "How are you doing?" and you say, "I'm fine, I'm okay," that's what your medical records are going to say. Patient is fine, patient is okay. And when Social Security reviews them, they're going to say, "I don't see a disability here. If they're fine, if they're okay, then they can work." So you need to make sure that you are very forthcoming about your symptoms with your medical providers. And so you will also need to make sure that you are reporting not only your symptoms, but if you're able to keep any sort of diary or log that gives us an idea of kind of your typical day. Some people will take naps at specific times as part of their treatment routine. So things like that all need to be documented to help to prove the severity and how the narcolepsy impacts you in terms of day-to-day functioning. Sometimes I've seen some sleep studies that may have been normal or may not have been abnormal to the degree that the physician expected. And the physician explains, well, this happens, even though this was a normal sleep study, I believe that my patient has narcolepsy because of X. So there needs to be some support for the diagnosis, some report of your symptoms, some report about how you are responding to medication. So I know that it's very common to try many different medications and sometimes not have good results. And so you need to make sure that you are reporting any side effects or any issues with this just isn't working to your doctor as well. And if you have a supportive doctor that is willing to write a letter or fill out a form or make a statement, about the severity of your conditions. That will be very helpful in your disability case as well. Next slide, please. So we have all this medical evidence, and we're able to prove that, okay, the narcolepsy is severe. You also have to be able to prove that you're not able to work because of the severity. And oftentimes, for people that go out of work, it is after a long period of doing the best you can for as long as you can, and the symptoms just worsening. If you are still working and you are having any difficulties performing your job, it is critical that you are keeping up with things like performance evaluations. If there is a trend and you can see high performer, high performer, high performer, and you can see a decline in the evaluations due to your symptoms, then it's important to keep that documentation. If you are receiving any sort of accommodations, or you previously received accommodations at work and you have that paperwork, it's important to keep that paperwork. It will help Social Security, excuse me, to see that despite the symptoms that you were having, the difficulties that you were having, that you continue to work for as long as you could. If there are issues with attendance, missing work, arriving late, leaving early, keep documentation. You can submit that to Social Security to show the difficulties that you've had. Any disciplinary warnings being written up. I've had clients that were falling asleep at work and they were written up. And it didn't have to be a formal write-up, but an email. All of those things count as a proof of the difficulties that you're having. If you've been to any sort of vocational rehabilitation, work readiness programs, you can submit those records. And of course, if you are a student or you have been a student and you had IEP, 504 plans, any sort of accommodations, teacher evaluations, all of those things can help. And then I shouldn't have put this last because it's pretty important. Hire an attorney. Attorneys can help put all the pieces together to best prove your case to Social Security. Next slide, please. I get a lot of questions about hiring an attorney for disability cases. We are not like your typical attorneys for many reasons, but one of the biggest reasons is that we are not paid hourly where you have to pay a retainer to hire us. For Social Security disability attorneys, we are paid on a contingency basis, and we have to be approved by Social Security in terms of representing you. And they make the rules, which is great. So what Social Security says is you don't have to have an attorney, but it's strongly recommended. This case is important. Excuse me. You have many potential years of benefits at stake. So it's important to have someone that knows how the process works, knows the rules and regulations and potential pitfalls to help you. So Social Security regulates how attorneys are paid, and they create the rules. And they say for an attorney to be paid, they have to be paid on a contingency, and they have to do two things. One, they have to win your case for you. Your attorney cannot get paid if they don't win for you. The second condition is that your attorney has to get you some back pay. So back pay is also known as past due benefits. We talked about how long the process can be. And because that process can be so long, most people are going to accumulate past due benefits while they wait. So there are people that may have waited for 2 or 3 years, they get approved, and Social Security owes them years worth of back pay. And so your attorney is paid out of your back pay. And they are paid attorney's fees, which are 25% of your back pay up to the maximum cap. And Social Security puts a cap on how much attorneys can be paid. Right now, that cap is $7,200. And it's been that way for almost 2 years. It does go up this coming November 30th to $9,200. So what that means is, as an example, if Social Security finds that you're disabled, they calculate back pay and they say, we owe you $100,000 in back pay. Then your attorney's fees are 25% of your back pay up to $7,200 if they approved you today. So it's the lesser of the two. It's the lesser of 25% or the cap. If you get approved for benefits and you get no back pay, then you do not pay the attorney a thing. Okay. And Social Security actually makes the payment directly to the attorney. So they kind of take you out of it. They put your back pay to the side for the attorney and they pay the attorney directly. Next slide, please. I know that I've gone over a lot of information, and so I provided my contact information. In the event that you have any questions that are not answered today, please feel free to reach out to me, and I'm happy to provide you with some guidance. With that being said, I will open up here. Let's see, I've got some questions that I will go ahead and answer. The first question that I have asks, what if you haven't worked for 15 years because of extreme fatigue, but didn't know that you had narcolepsy until 3 years ago, and you've had no income for the last 10 years? So if you are single, then we'll have to look at your assets. Because you could still qualify for SSI, which is the Income and Asset Sensitive Program. So since you haven't worked in the last 10 years, you are not going to likely be eligible for SSDI, but you may be eligible for SSI as long as you meet the income and asset requirements. So I encourage you to reach out to an attorney and talk about the specifics of your case or your potential claim to see if you can apply for SSI. But based on the facts that you have provided me, you should be able to apply for SSI. The next question, let's see here. Okay, someone said, who do we even meet with or talk to just to start this process? My parents aren't willing to help out, and I want to advocate for myself and my needs. Excellent. You can reach out to an attorney. You can feel free to contact me. I'm happy to talk with anyone, like I said, to answer any questions. Again, this is a federal program, so my clients live all over the United States. Or if you prefer to talk to another attorney, you can certainly reach out to, there's an organization called NOSCR, NOSSCR, and that is an organization for people like me that represent claimants in Social Security disability cases. The next question is the team in the reconsideration team, is the team in the reconsideration stage the same team that denied you the first time? Great question. Sometimes yes, oftentimes no. So what should happen is that you get a new physician or psychologist to review, but they typically will adopt the previous denial. And that's why we see 90%-ish of people that will be denied at reconsideration. So it can be a different team, but the results are often the same. And when we're dealing with rare conditions such as narcolepsy, it is much more difficult for people to understand the impact. And so I see in a lot of cases with sleep disorders or just rare conditions, period, they don't know what they don't know. And so it becomes much easier to assume that people can do things, and that results in denials. And so we often have to go to a hearing in cases where clients have rare diseases. Next question says, can you apply for Medicaid for health coverage while you're waiting for Medicare on an approved SSDI claim? So you can. What we see happen often is when people apply for Medicaid when they've got a pending claim, is, at least in Georgia, I often see that there will be a denial and they will say, well, you've got a pending disability claim. I would say it can't hurt to apply. Best case scenario, you get approved in the interim. But like I said, in Georgia, you're going to get a denial while you've got that pending claim. Another great question I see here, can you still appeal a denial past 60 plus days for a valid reason? So there is a process where you will be asking for or providing good cause. So it's called good cause. So you can appeal it, you just need to provide good cause. So you're going to have to explain to Social Security why you missed the appeal deadline. You know, sometimes people are hospitalized, sometimes people have moved and they didn't receive their notice. So there are many reasons that you can provide that could qualify for good cause, and Social Security will let you know if they accept it. So if you've missed the deadline and you feel like you have a good reason, I encourage you to to go ahead and appeal and provide a good cause explanation. If you're working with an attorney, they will handle that for you. Here's another question. Let's say that a person gets approved for disability, receives it for a while, and then they start making more money, more than the $1,550 per month. Does a person need to report that increased income right away? If they make that increased income for a year, then go back to no earnings, do they have to reapply for disability all over again? Another great question. So the short answer is it depends. It depends first on what program you're receiving disability from. If you have applied and you're receiving disability from SSI, first thing that you need to do is you need to report your earnings every month. If you do not report your earnings, then you are going to end up with an overpayment. So with SSI, your earnings, the amount of money that you receive in SSI is going to change based off of you working. And so you need to make sure that every month you're reporting it. Under this question, if you have SSI and then you start making more than the $1,550 per month, and of course you need to report that the earnings, then you're going to end up being ineligible for benefits. Ultimately, they're going to find, well, you're not disabled because you are engaging in substantial gainful activity. On the other hand, if you are receiving benefits under SSDI, then they've got a special set of rules. And with SSDI, they have something called a trial work period. And the way that it works is with the trial work period, Social Security is saying, I know that you're disabled under this program, but I want you to try to go back to work and you're not going to have a penalty. And they allow you to work under this trial work period, and you still need to report your earnings every month, but they allow you to work without penalty for 9 months. Doesn't have to be 9 months in a row, but you get 9 months, excuse me, where it doesn't matter how much money you make, you are still going to get your SSDI payment. Once you exceed that trial work period, then what happens is you go into a period, it's extended period of eligibility is what they call it. And so the 10th month, for example, let's say you make $2,000 again, you're not going to get your check. Okay. And so they are not going to pay you as long as you are exceeding substantial gainful activity at that point. But if you stop working, then you can contact Social Security and say, hey, I used all my trial work period and I worked 7 months after that, and then now I can't work again. And your benefits should be reinstated from that point. the next
Angel,
question.
I think
Yes.
if you want to look, we want to be mindful of your time. This has been amazing. But if you see anything that you want to answer live, we can do that. But everyone, I would encourage you to take down that information. A recording will be available this later on Wake Up Narcolepsy's website. But do you see anything else that you want to hit? People can reach out later if they have questions.
Sure. Sure. Okay. So I see one more here. If you are approved for disability and you move to another state, do you have to start the process over since you said states supplement the payments? And no, you do not have to start the process over. You just need to contact Social Security, your local office, and let them know that you have moved and provide them with your new contact information.
That was a great question. Thank you so much. Every time I have listened to you and I've learned so much, and I just think there's an opportunity here for people to move forward in ways that they've maybe been stuck before. And so thank you so much for being here and sharing all of this information. Again, a recording will be available on our website in a few days. And I want to thank our sponsors, uh, our Diamond Champion sponsor, Jazz Pharmaceuticals, Gold Champion sponsor, Avidel Pharmaceuticals, Silver Champion sponsor, Harmony Biosciences, and program sponsor, Takeda Pharmaceuticals. Thank you everyone for joining, and thank you, Angel.
Thank you.